Hello, my name is Lisa Waddington, and I'm Professor of European Disability Law at Maastricht University in the Netherlands. My professorship has been established by the European Disability Forum in cooperation with Maastricht University, and I'm speaking to you today in a personal capacity. So thank you for the invitation to speak to you about the right to free movement of persons with a disability. So in principle, all EU citizens have the right to free movement and the right to reside in a member state other than the one of which they hold the nationality. This is what we mean when we talk about the right to free movement. Certainly, there are no EU law restrictions or limitations on this right which explicitly refer to disability or to people with a disability. However, EU law does allow the member states to deny EU citizens from other member states the right to reside in their territory in a limited number of situations. These situations, which can be regarded as exceptions to the right of free movement, are in general designed to allow member states to protect certain elements of their society, including the social welfare system, and to discourage what is called welfare tourism. As a consequence, in some situations, individuals who do not have sufficient resources to support themselves and who require financial support from the state of residence, so the state of which they want to move to, these citizens can be denied the right to reside, or if they have that right can be removed. Now, this can be particularly important for persons with disabilities who are more likely than the general population to be unemployed and also to be in receipt of welfare benefits. And therefore, people with disabilities run a greater risk than the general population of finding themselves in such a situation. So what I want to do in this short talk is to look at the right to free movement with regard to two groups. Firstly, economic residents. So those are workers, self-employed people and their families. And secondly, non-economic residents. So that's anyone else who want to go and reside in another member state. And I want to look at the disability-related barriers. So workers and self-employed people are the most privileged category of EU citizens when it comes to exercising the right of free movement. Workers and self-employed persons are entitled to reside in another member state. They are entitled to receive equal treatment to nationals from the point at which they take up residence. So equal treatment is provided with regard to work-related matters such as pay, protection from dismissal, working conditions, but also in other areas such as access to public housing, taxation and benefits. So a disabled person who is a worker or a self-employed person can claim and receive all disability-related benefits on the same basis as nationals in the host member state. So that includes financial benefits and grants, it includes access to specialised equipment, it includes provision of personal assistance for either work or personal life. Workers or self-employed persons can also be accompanied by family members, so that's the spouse or partner, their children and other dependent family members. And these family members, if they have a disability, can also claim and receive all disability-related benefits on the same basis as nationals. So one key question is, who is a worker? And do disabled people find it more difficult to acquire this status than others? Now, the Court of Justice of the European Union, which interprets EU law, has elaborated on the concept of an EU worker in its case law, and its definition of a worker is quite broad. So an EU worker is someone who carries out economic activities under the direction of an employer and who in return for these activities receives remuneration. The work has to be genuine and effective. An individual can work a limited number of hours and receive a fairly low remuneration, but they can still be, and in fact an individual can still need to claim benefits from the host member states in some circumstances and still be a worker, but there are some limits. So where a person with a disability works only a very limited number of hours, and it's difficult to say exactly what the line is, but less than 12 hours per week might be problematic, or where a person with a disability earns only a very limited amount of money, they may not qualify as a worker under EU law, and therefore they may not have the right to move to another member state as an EU worker. There's also some old case law from the court which suggests that persons with disabilities employed in sheltered workshops or supported employment may not qualify as EU workers. Although that case law is quite old, there's more recent case law which goes in a different direction, so it's difficult to say what the definitive situation is here. So to sum up, persons with disabilities who are able to acquire the privileged status of EU worker or self-employed person and their disabled family members are able to exercise the right to free movement, and they acquire the entitlement to claim all disability-related benefits on the same basis as nationals from the moment at which they take up residence. And claiming these benefits cannot lead in them losing the right to reside in the other member state. However, the failure to recognise as EU workers those individuals who earn a very low income, individuals who work a very limited number of hours, or individuals who are employed within sheltered or supported employment possibly, can mean that some persons with disabilities find it more difficult than persons without disabilities to acquire this privileged status of EU worker or self-employed person. But even if a disabled person is able to acquire this privileged status and therefore entitled to claim and receive disability benefits in the host member state, in the new member state, on the same basis as nationals, they can still face significant administrative barriers which hamper free movement in practice. So the benefit system is different in the different member states. Benefit which exists in one member state may not exist in another member state. And even if a comparable benefit does exist, the eligibility criteria and assessment procedure are very likely to be quite different. So a person might qualify for an important, indeed an essential disability-related benefit in one member state, such as personal assistance allowance, but they may not qualify for the same benefit in another member state. It might not exist, or they might not be eligible. And even if they do qualify, they may face a long assessment procedure and a period of uncertainty. And de facto that leaves them without support, the support that they need in the first months after moving to another member state. Now, of course, this can also happen when a person moves from one municipality to another municipality within some member states. But the problem is likely to be compounded, more challenging when a person moves from one member state to another. Now, the second category of beneficiaries of the right of free movement consists of non-economic residents. So this category covers students, pensioners, and the residual category of all other EU citizens. Now, individuals falling into this category have a number of conditions attached to their residency, which do not apply to workers, self-employed people, and the families of workers and self-employed people. For the first 5 years of their residence, non-economic residents must not become a burden on the social assistance system of the host member state, and they must have comprehensive sickness insurance cover in the host member state. So those words are taken from EU law, in fact. In spite of this, in some cases, non-economic residents, like students and pensioners, can rely on EU law to claim a disability-related benefit in the host member state, the new member state, during that first 5 years of residence. But if a non-economic resident successfully claims a social assistance benefit, they may risk becoming a burden on the host member state, and those are the words of EU law, and this entitles the host member state to end both the legal residence and then the entitlement to the benefit. So in short, non-economic residents who claim a disability-related benefit during their first 5 years of residence, which leads to them becoming a burden on the social assistance system of the host member state, can lose that right to residence. Now, after 5 years of legal residence, these non-economic residents, students, pensioners, for example, are entitled to full equal treatment with nationals. And that means they cannot lose the right to reside if they claim a benefit. So all of this means that having sufficient resources to support oneself and to support one's family is a key requirement for individuals who want to exercise the right of free movement and who are non-economic residents. Now, the possibility to export a disability-related benefit, such as a disability pension, from the member state of origin to the host member state might enable an individual to meet the necessary income requirements and therefore to avoid becoming a burden on the social assistance system of the host member state, and thereby this enables them to exercise the right of free movement. So, if you've got a disability pension here in the Netherlands, and you're able to export that to Belgium, so you move to Belgium and you still retain your right to the Dutch disability pension, then this can enable you to have sufficient resources to support yourself. And EU law is relevant here because it's long been recognised that, for example, losing the right to a social security benefit when a person moves from one member state to another can be a major disincentive to exercising the right of free movement. So the EU has long had legislation which seeks to coordinate social security systems amongst the member states, and the relevant EU law provides for the exportability by individuals of certain listed social security benefits, including disability or invalidity pensions, as they're sometimes called, and also sickness benefits. So these can be exported from one member state where the entitlement to the benefit was originally acquired to another member state where the individual goes to reside or live. I should stress here that EU law has never sought to establish a common social security system or harmonise the national social security systems. So there are no rules, for example, providing for a common level of a disability pension or any other common disability benefits. So EU law only aims to coordinate member state action. There is no goal of harmonisation. In terms of the benefits which can be exported, these are social security benefits covering sickness and maternity, invalidity or disability, old age benefits, survivors' pensions, benefits in respect of accidents at work and occupational diseases, death grants, unemployment benefits and family benefits, where they are social security benefits. Social and medical assistance are excluded. These are not exportable. Long-term care benefits, such as the provision of personal assistance, are not explicitly addressed in the relevant EU law, but the Court of Justice of the European Union has allowed the exportability of some of these benefits by classifying them as sickness benefits. Sickness benefits can be exported. And this classification is not always an easy fit with the kind of benefits that we're talking about. It's important to realise that EU law, whilst allowing for the exportability of social security benefits, does not allow for the exportability of social assistance benefits. So that means that disability-related benefits which amount to social assistance fall outside the scope of the relevant regulation. They cannot be exported under EU law. However, EU citizens who are resident in another member state are entitled to claim these social assistance benefits, although remember that requirement that non-economic residents should not become a burden on the social assistance system of the host state during their first 5 years of residence. It's also worth mentioning that the possibility to export social security benefits only applies to cash benefits. So it only applies to benefits which are paid in cash, and this means that a distinction has to be made between cash benefits and benefits in kind. Benefits in kind are, for example, the provision of a number of hours of physical care or personal assistance, and these benefits in kind, it would also include specialised equipment. These are not exportable under EU law. So in short, an individual who is entitled to receive a disability-related social security benefit which is paid in cash is entitled to export that benefit to another member state. and this may mean that they have sufficient means to support themselves in that other member state, and therefore they're able to satisfy the conditions to exercise the right to free movement. Benefits in kind, such as the provision of a number of hours of personal assistance or specialised equipment, and also benefits which are social assistance, are not exportable. These can only be claimed in the state of residence. So relocating or exercising the right of free movement and going to another member state can imply, under EU law, a significant and unsustainable loss of support, meaning that de facto an individual is unable to exercise that right to free movement. So in conclusion, there are a variety of possibilities for persons with disabilities to exercise the right to free movement. EU workers and self-employed persons have this right, as do their family members. The EU definition of worker is fairly broad, but individuals working a very low number of hours or earning a very low income are excluded, as are possibly people working in sheltered or supported employment. And these restrictions may limit, directly or indirectly, the possibility for some disabled persons to acquire the status of worker, and that is the status which gives them the right of free movement. Non-economic migrants also have fairly extensive rights. So these are students, pensioners, and other people who are not working or family members of workers. But the requirement that the migrant must not become a burden on the social assistance of the host member state, and again, this is I'm quoting from EU law here, this can pose a barrier to free movement of persons with disabilities who do require financial support or benefits in kind. But to some extent, persons with disabilities can meet the income-based criteria for free movement by exporting a disability-related or other social security benefits, such as an old age pension, from their original member state to the new host member state. And while social security benefits can be exported in this way, social assistance benefits cannot be exported, as is, as I say, the case for benefits in kind. And this combination of a lack of exportability, along with the absence of a right to claim equivalent benefits in the new member state on arrival, can be a significant disincentive to exercising free movement. Also, when an individual does have the right and is entitled to claim and receive benefits in a new member state, there are still numerous administrative barriers which can also hamper the right to free movement or make it more difficult for the person to move to another member state. Thank you very much for your attention. I wish you a very successful conference and a very successful Freedom Drive.